Hey everyone, I'm Phil Bergren. I am Chief IP Counsel for Monotype, and today I'm going to talk about our approach to font enforcement, what we've learned over the last 5 years or so that we've been trying something new, and hopefully you can learn something too. So who am I? I have a creative background. I was a jazz musician with a music scholarship in college, and I thought that was the direction my life was going to go, and kind of just fell into law school. But I am a lawyer. I'm also very, very much an introvert. These types of public speaking opportunities are not my comfort zone, but I hope the content gets through the same. So bear with me a little bit. For some background, we're talking about intellectual property, or IP, which is legally protected creations of the mind, as opposed to creations of the hand or physical creations. And we're primarily talking about copyright and trademark rights. Copyright rights protect art and literature or other creative expression, not any ideas, concepts, facts, discoveries, methods, etc. Those are, to the extent protectable, are fall under largely the patent realm of protection. And then we also talk about trademark protection, trademarks being a unique identifier used in connection with a particular good or service in commerce. And with trademark protection, it's interesting because the goal here, the reason there's legal protection is to really protect consumers. So when they buy a product with a particular name on it, they know that that is the same source as any other product that has that name on it, or any other similar product with that name on it. So if I buy a bottle of Coca-Cola, I know that's going to have the same origin when I buy it from the store in Tennessee versus the store in Illinois. It's not going to be made by Joe's soda shop in a bathtub or something. Font IP is weird. It's pretty unique compared to most other areas of intellectual property. And when we were going through this, in order to have a truly global framework and a global process, we wanted to make some key assumptions that would enable us to not have to bend to each individual jurisdiction's idiosyncrasies. So one thing to keep in mind with all intellectual property is these rights are national in nature. There is no um, single global copyright law or global trademark law. It's all based on what's been enacted through local legislatures. But there are several themes. So one theme that we picked up on in the US, there is no entitlement to copyright protection for typeface designs, but there is copyright protection for font software. Other jurisdictions around the world differ. There's not really a consensus. Some explicitly protect or recognize copyright protection for typeface designs, others don't, and the vast majority are just silent on it. So if we take that, can we be effective if we assume that there is no copyright protection for typeface designs and instead rely on the copyright protection present in the font software? We found that we could, and that's one of the key assumptions that we made is that when we're talking about enforcement, we're talking about copyright enforcement of the software, and not going down the pretty hairy legal argument of whether there's copyright protection for the typeface design. We also know that trademark rights are very strong, as long as the trademark itself is distinctive. So there's a spectrum of what is more protectable or less protectable under trademark. And the more distinctive or unique the trademark is, the more protection it's going to be entitled to. And we do rely on that so that we know that we are the only source of Helvetica font software. We have trademark registrations for Helvetica in many jurisdictions around the world, and we've been using it along with our predecessors for many, many years. So we know that we can ensure our consumers are getting genuine Helvetica font software because we're the only ones that are authorized to use that name in connection with fonts. There are also, it's kind of funny, there are a lot of parallels between fonts and other industries. For example, the fashion industry, there's a couple of parallels with the music industry and recipes. So with fashion, like typeface designs, fashion designs are not protectable by copyright, but they still have a thriving industry. recipes are instructions. They're facts or a procedure that's written down, not entitled to copyright protection, but still there's a market for recipes. And the lack of copyright protection has not slowed that industry or content creators. With music, the similarity there with fonts and typeface designs, you have these two layers. You have the design itself and then the software that renders it. With music, you have two splits as well. You have the the composition. There's a copyright protection for the composition of a song or a piece of music, as well as copyright protection for a particular recording of a piece of music. And those two play into each other, but they could have different owners or the same owner for each piece. When I was initially looking at what Monotype was doing with IP enforcement, I was looking at the history that I saw, and growing up in the Napster world, I I looked at what happened then with the record industry and the movie industry, and specifically the giant planet that is or was Metallica and Metallica's efforts to shut down Napster and to really take a heavy hand, filing lawsuits all over the place, generating a lot of ill will towards the industry. And I wanted to see if I could reject that. I also looked at the struggle itself. So if we are starting with the assumption that there is no copyright protection for the design, that is a huge piece of what people want when they're purchasing licenses for fonts. They care about the design, and they wouldn't necessarily understand that the design doesn't have strong copyright protection with it, even though that's what they really want to pay for. So we have these weakish IP laws. We also have a situation where when developers are creating products, they're not typically tracing down all licenses for the stuff that goes into them. And if a developer is told by a designer to use a particular font, they'll often just search their computer, copy it from their font folder, look on the internet, download the font name or what they think the font is from a potentially nefarious website. Um, and so in that regard, fonts are kind of like water where they filter through everything. They find every crack, and sit there. And I also wanted to be focused on the court of public opinion. I didn't want to do something that would that I'm not comfortable doing personally. I also don't want to do anything that will harm the reputation of my employer. And I think there's a way that we can be successful, protect the IP, and not take the heavy-handed approach that the record industry took in the early 2000s. And it reminded me, there's a Jack White. You know, say what you will about Jack White, he's definitely a character, and he was giving an interview where he talked about how he really embraces the struggle for his creative process. When he's doing live shows, he'll put his pedals and microphones as far away from where he is as possible so that he can still hit them, but it's a struggle. And he thinks that that struggle gives him some kind of edge. So, can we embrace the struggle here and have a process that really works for us, our IP creators, and our customers? How do we solve for the future? How do we get to that nirvana stage where everyone is happy, everyone recognizes the value, and we go about our day? What we found works really well is we take an approach based on honesty, accuracy, and empathy. And this has been really helpful in our process for a lot of reasons. This is all super straightforward. Um, if you tell the truth, you don't have to remember what you said because you'll come back to it. Um, Facts are great. If you're accurate, facts are irrefutable and undeniable. At least they should be. And the last one really spoke to me. There's a quote from the Dalai Lama: "If you want to be happy, practice compassion." This looks like a pretty happy guy. I'd like to aspire to be more like that. So, can we practice compassion and help bring everyone a little bit more happiness? The process that we laid out is based on a few different phases. So we have a research phase, a claims analysis phase, the outreach phase, and a resolution phase. Within each of these, it's important to go in order and to build on each other. So the research phase is really the foundation of everything. Um, we look at how fonts are being used by prospective customers, what fonts are being used, and whether there's a license covering the discovered use. On the analysis side, this is applying the facts that were gleaned during the research phase to the law. Do I have legal rights to the font IP, and are my rights being infringed? This is really the component of this that, in my opinion, requires more. It's more legal analysis. It really does require a lawyer to be involved in this process to actually advise and stand behind the guidance. On outreach, this is probably the the hairiest part of the process. There are a lot of factors here, and in the particular approach we take depends on the research and the analysis. So we typically would look at this fresh for every issue that arises. We talk about who makes the first approach, whether it's someone in the business organization or a lawyer. What do we communicate? And how do we communicate it? Our goal is to have an educational conversation with compassion, where we understand that the person or the entity that we're reaching out to didn't intentionally try to rip off our IP or the IP of our partners, that they just need to understand a bit more. And we've had a lot of success with that. On the resolution side, once we've built up the research, we know what our rights are, we've had a conversation with the potential client, we just need to resolve it. And our approach has been to focus on the future customer relationship. So we came to the table with under less than ideal circumstances, potentially. Nobody wants to get a call from a lawyer or a letter from a lawyer, but we found that when we explain our position, that these are this is creativity, that there are IP rights associated with it. We pay royalties back to designers, and when we're trying to resolve these issues, all we're looking for is just the license fees that would have been paid had the use been licensed up front, as opposed to further down the road. And we really try to find solutions that ensures a long-term customer relationship. And what I like to do, I like to include this slide. I call it the enforcement rainbow of success, where if everything goes well, you have this nice rainbow, and on the other end of it, you have a happy customer, a happy foundry partner, and a go-forward relationship, as well as you've educated the once infringer on the nature of font IP and licensing. And one of the things that Monotype started doing recently is actually partnering with third-party foundries and bringing them into some of our enforcement portfolio. So we have a mechanism where new foundries that sign up, we will include that IP as part of our review when we're reviewing other clients' use of fonts, and to the extent the third party's fonts are being used, we will resolve those issues on behalf of the foundry and build them into the go forward solution as well. So we have seen a lot of success with this. We've built a lot of successful customer relationships, and I am happy to answer any questions that you may have.